Electoral Commission. Second respondent represented by Dr. Kujafari, Chairman. National Democratic Congress. Represented by Johnson and Petition. General Secretary.
Respectfully, my lords, I appear for the petitioners. With me, Ms. Gloria Kufu. Frank Davis. Alex Quino. Akoto Ampa. Kweku Isirfi. Godfrey Yeboadame. And Egbert Fable Jr.
May it please your lordship, I appear for the first respondent, the president. My name is Aziz Bamba.
May it please your lordships, I appear for the second respondent, and with me are my learned friends Stanley Amatefiu and Frida Bruce Appiah, my lords.
If your lordships please, I appear for the third respondent, and with me my learned friend Samuel Kojo.
Application for leave to remit part of issue to referee for further consideration thereof is hereby called.
Well, we've decided to introduce time for the addresses, so 10 minutes per person. 10 minutes. Yes.
My Lord, before I start, I'd like to draw your attention to an error on the motion paper. This motion is being brought under Order 28, Rule 4, 3, and 4 of CI 47, not 75. My Lords, I move in terms of the motion paper and supporting affidavit. Lord, this application, as I indicated earlier on,
I've indicated this.
Yes. Under Order 28, Rule 4, 3, Sub 3, and 4. My Lord, Sub 3 provides that on receiving the referee's report, the court may A. adopt the report in whole or in part, B. vary the report, C. require an explanation from the referee, D. remit the whole or any part of the question or issue originally referred to the referee for further consideration by the referee or any other referee, or E. decide the question or issue originally referred to the referee on the evidence taken before the referee, either with or without additional evidence. And 4 provides that notwithstanding Sub-Rule 3, where the report of a referee has been made in a course of matter which has been adjourned, any party may on the next hearing date apply orally to the court to adopt the report, or with leave of the court give not less than 4 days notice by motion for the court to vary the report or to remit the course of matter or any part of it for rehearing or further consideration to the same or any other referee. My Lords, as indicated on our motion paper, this application has been brought firstly to determine the polling station names and codes of the 1,545 pink sheets with incomplete data and determine the unique count thereof. And to do so with the aid of either the further and better particulars filed by the petitioners or the official list of 26,002 polling stations established by the second respondent for the 2012 general elections. Secondly, to determine the unique count of the 2,876 pink sheets that the referee's report establishes as part of the set of the president of the panel, but which is not contained in the set of the court registrar. Lastly, to determine and produce the full list of the unique count of the aggregate of 8,675 unique pink sheets. The unique pink sheets is the 1,545 pink sheets described in the report as having uncleared data, and the unique pink sheets in the 2,876 pink sheets in the set of the president of the panel. My Lord, This application has been necessitated by the fact that these matters that we seek to have considered by the court leaves the report incomplete. My Lord, with respect to the 1,545 pink sheets which the referee says are unclear, the referee itself has sought that further directions be given by the court with respect to those pink sheets. Indeed, the petitioners on their part have identified fully the 1,545. And in this respect, I refer your lordships to the report at page 12, where the petitioner says, the referee's report, page 12, where it says that a decision will need to be made as to whether the missing information of the remaining exhibits will have to be provided or sourced to determine whether or not they do indeed qualify to be included in the list. It's an exhibit.
Yes, so I think you go by that. Yes. Otherwise, you are introducing extraneous matters and then we will go.
Very well. Exhibit, another Exhibit 1, page 12 of Exhibit 1, Court Exhibit 1. My Lord, with respect to the 2876 pink sheets in the President said, nothing is said about the unique counts. This whole exercise is to determine the number of pink sheets that has been filed by the petitioners in relation to the polling stations as set out in their affidavit. And therefore, it is important that of the 2,876 pink sheets found in the President's set, but not in the registrar's set, the referee indicates how many of them are unique counts, just as it did in respect of the registrar's count, where it indicated the unique count to be 8,675. My Lord, the petitioners on their own have been able to establish that out of the 2,876 pink sheets, there are 871 unique counts in the President's set. 871. Now, it's our contention that if these unique counts are made, it will be clear for all to see the number of polling stations that have been filed by the petitioners. and this will greatly assist the court in this exercise. My Lord, by the petitioner's count from the register of 8675 added to the 871 from the president's set, and then the 1,291 unique out of the 1,545. In addition to the 648.
It's okay, because now you are giving it what the work you want the man to do. So if you have anything to add to your affidavit, because your time is almost up. So add anything you want to add to your affidavit. We've studied the affidavit fully. So is there anything else you want to add? Apart, that is, whenever they give you time, this is it. We've read it.
You've read everything, very well.
So add what you want to add.
Well, there's affidavit in opposition which I want to say a word or two about. Well, my Lord, we have received affidavit of opposition from all the respondents. The first and third respondents put the affidavits together. They rely on each other. Basically, what the petitioners are asking is beyond the mandate of the referee. We disagree to that. Lord, what we are asking is well within the report given by the referee.
And I found your invitation as run.
Very well. Very well.
Yeah, the residual.
My Lord, we are vehemently opposed to the instant application. My Lord, this application is one of the species of applications filed by the petitioner to unduly prolong the hearing and the conclusion of this case. The application lacks merit and should be dismissed. My Lord, our specific grounds for opposing this are set out in our affidavit, the first respondent's affidavit, and also the third and affidavit. I'll be very, very brief in talking about our main grounds of opposition. My Lord, the order given to the referee is quite specific in terms of what the referee should do. Very, very, very specific. There's no ambiguity about the order. Well, I've not referred to the exact terms of the order, but our contention is that the order being specific, the instant application doesn't come within the contours of the original mandate given to the referee. My Lord, this application is also not about a truthful and faithful count of the exhibits filed with the registrar. Far from that, this application is about establishing the identity of pin sheets of polling stations. And that was not the original mandate of the referee. The original mandate was essentially...
It's on page 1.
That is true, my Lord.
The bullets 1 and 2, and then the president's, the subsequent court order dated 5th June was added to make the president's copy. It's also on page 1.
Okay. That is true, my Lord. My Lord, if, just for clarity and for illustration, I'll read a specific order given by the court. To make a faithful and truthful count of all the exhibits of pink sheets delivered by the petitioners to the registrar of the Supreme Court, according to and under the various categories of alleged electoral malpractices, as appearing contained and specified in paragraphs 44 to 67 of the affidavit of the second petitioner, filed in the registry of the Supreme Court on 7th April 2013, and specifying in respect of each pink sheet its exhibit number, if any, as well as its polling station name and code number. Well, there is nothing in this order that makes you reference to identifying Elizabeth using further and better particulars, relying upon the list of polling stations from the second respondent. The order was specific. What has been filed with the registrar? Count that. What the petitioners are seeking to do now is basically for the referee to help them identify polling stations. And as I'll demonstrate shortly. My Lord, if I may. Yes, specifying in respect of each pink sheet its exhibit number, if any, as well as its polling station name and code number. My Lord, that is what has been filed as it appears from what has been filed. So if what has been filed hasn't got any data for the purpose of identifying the pink sheet, that does not come within the order of the referee.
What was the basis for the referee asking for direction in the court? If this is what you are holding on to.
So it lies in the power of the referee.
Asking the court for the direction.
My Lord, if he's, with all due respect to your Lordship, if he's asking for directions, I mean, that is a separate issue as to whether the direction is seeking in the original mandate of the referee. It's an issue for the court to determine. But I'm saying that, and for the other arguments that we are going to make, this application should not be, because in doing that, other legal matters are involved. One issue, for instance, they will be shifting the burden of proof, because as petitioners, when they filed those exhibits, of course they knew the content of those exhibits before they filed them. They must have known the content of those exhibits. If there were any issues of clarity, they should have known about them. So this is not the time, I mean, for them to be seeking a referee's assistance to establish the identity of polling stations. And what in addition to that?
At least there were exhibit numbers on them. So you could at least have listed the exhibit numbers.
Well, he has
1,545. At least the exhibit numbers will be clear.
Well, the ones that are clear have been listed in the report.
What about one? So it means not even a single of the 1,545 had an exhibit number and commissioners of oath stamp on it.
My
I
Lord,
haven't seen any here. So
my Lord, the unclarity covers a number of areas.
Yes.
Some of them have to do with lack of exhibit numbers. Some of them have to do with no polling station names and so on and so forth. But the issues relating to lack of clarity, those polling stations have all been listed. All of them, in any case. I mean,
is there 1,545 in any of these reports?
My Lord, they have been listed. If I...
And are they listed in there?
They are
any
listed.
of these exhibits?
My Lord, if I...
1,545.
They've been listed. But, my Lord, in any case... My Lord, in any case, if there is an issue... My Lord,
expired.
Oh, my Lord, 10 minutes. I will... I think your Lordship is part of my time. So if I be granted extra time...
There's a representation affecting me here, but very well, 1 minute.
My Lord, I rely on the... I rely on affidavit in opposition and the one filed by the third respondent. I think this application is even incompetent because Order 28 clearly is not a basis for this application. Order 28 talks about when you receive the report. This report is already in evidence. What they are seeking to do is to recall that is already in evidence, and that is clearly incompetent. So I pray accordingly that this application be dismissed.
Yes.
My Lords, I am relying on the affidavit in opposition that we have filed to this application, and I wish to emphasize in particular that having contested the elections in all 275 constituencies in Ghana, and having appointed agents to all the 26,002 polling stations in the constituencies, and having been able to file the initial petition, the first amended petition, and the second amended petition, in addition to several interlocutory applications before this honorable court, and the lengthy affidavit filed on behalf of the petitioners by the second petitioner. At this late stage in this suit, the instant application is to cause an undue delay in the trial, bearing in mind that the burden of proving their case lies on the petitioners. My Lord, these are the grounds on which we, as second respondents, are opposing the instant application. My Lord, I would like to donate the rest of my time.
My Lords, I accept the donation. I oppose to this application, and I would associate myself with the submissions made by the first respondent in respect of matters to which we have deposed affidavits, and also to the legal submission just made by counsel for the second respondent. My Lord, I would further point out, in response to a question that counsel for the first respondent was asked, that Appendix E5, which is in Volume 5 of the report, explicitly sets out the exhibit numbers of the 1,545 exhibits that are stated to be unclear. Not only that, Volume 1, the report itself, in Appendix A1 to Appendix A2.1 to Appendix A2.24, where the data is captured according to the category from paragraph 44 of the affidavit to paragraph 67, wherever the exhibit number is, wherever the exhibit is coded with whatever identification marks are available, those are recorded. And in the remarks column, there is the indication of whether it's an unclear polling station code or whether it's an unclear exhibit number or whatever unclarity there is. So the report of the referee addresses both 1 and 2 of your Lordship's order comprehensively. Petitioners are here seeking to do is effectively go outside the orders that were given by this court to the referee. And I respectfully ask your Lordships to recall that the petitioners opposed the application for the referee to be appointed. They opposed it initially, and subsequently, when they agreed to it, then asked also for a cross-check with the presiding judge's set. They opposed that application for the cross-check. Now, the applicants herein are seeking the referee undertake some additional tasks, not only outside the terms of reference of the referee, but in our respectful submission, they will add nothing whatsoever that is relevant for the purpose of determining this case. Because the evidence of the representative referee explained how you can derive the unique pink sheets, the data that's been captured here. The referee explicitly indicated that you have a list, 3,205, which is the list of sheets that are duplicated and the numbers are indicated, and that list consists of the 3,205. With the rest of the 13,926, they also computed the number. So, my Lord, what we are talking about really is just the arithmetical counting. I draw your Lordship's attention also respectfully to the fact that these 8,675 unique polling stations that the referee's representative refers to includes exhibits outside the range. Now, we have the range in the affidavits in the particular paragraphs, and in volume 5, the referee's report also sets out, in respect of the PC, 139 polling stations that are outside the exhibit range just for the PCUs alone. So in fact, as we obviously in our address, those 339 clearly have to be deducted. Moreover, my Lord, as far as further and better particulars are concerned, the referee cannot be asked to go back to further and better particulars. Indeed, if that were to be the case, that would occasion enormous delay, because it would take at least as long a time to enter what has been entered in respect of the exhibits as it would take to enter the further and better particulars. And we will actually be submitting indeed that over 300, and we are still counting, but over 300 of the exhibits are not in the further and better particulars, and therefore should not even be part of what the court considers in its consideration of the evidence in this case. But that is a submission we'll make at the appropriate time. I simply draw attention to that in order to indicate that a recourse to further and better particulars takes us even further away from what your Lordship order is about, a count of exhibits actually filed in this case, and that is what the referee has done. My Lord, what is being sought to be done in this application is different from the matter that your lordships raised yesterday. Your lordships raised yesterday an issue of whether 0000 should have been put before certain numbers. That is a question that can be asked by simply recalling the referee's representative and having him address that issue. If that's the only issue, it should be done. I refer, my lords, finally to Order 37, Rule 2 of the High Court Civil Procedure Rules here. I'm sorry. Yes, I am winding down. Order 37, Rule 2.
37, Rule 2 will not give you more time.
Very well.
My lords, with your leave.
Yes, yes. 5 minutes, please.
5 minutes, very well. Lord, first of all, none of the respondents have made any allegation of unclear pink sheets in terms of identity of the polling station. The petitioners also have not made any complaint of unclear polling station name.
With respect, this has nothing to do with matters of law. It's basically rehashing facts.
Well,
I'm replying to their submission. I'm replying to their submission.
yes, what he's saying is that you can only reply to points of law. But this one is a technical matter, so I think...
Yes.
Yes.
So all the pink sheets that has been served on the respondents, that also the petitioners have, are clear. The polling stations can be identified. It is only the referee who says that some pink sheets are unclear. And it is only because the referee does not have full information to make that determination. Indeed, in excluding the 1,545, the referee uses grounds such as no ballot accounting session on the pink sheet. That is completely outside its mandate.
Respectfully, this is not a reply. Respectfully, this is not a reply. This is really reopening, re-arguing matters which have already been argued. This is not a reply. If we are going to have an additional 5 minutes by virtue of this leave to reply, then we should respectfully also be treated fairly in respect of that.
They do not. My Lord, I'll be done in a minute, except for these interjections. The other point is that...
Yes, but don't go outside too much. Yes.
These 1,545 pink sheets, if they had not been referred to the referee amongst the parties, would have been identified. They would have formed part of the evidence before the court. As it is now, they have been excluded by the referee, which will amount to suppression of evidence, because we know what these polling stations are. We have identified all of them.
Excluding.
I'm sorry.
Exclusion of evidence, not suppression.
Exclusion.
Yes.
Thank you, my lord. Very well. Exclusion of evidence. It amounts to a clear exclusion of evidence which the parties have identified. None of the parties have come to this court to say a particular pink sheet cannot be identified in terms of the polling station. And lastly, these unclear polling station names and codes are not the doing of the petitioners. They are not the doing of the petitioners, as the respondents seem to say. These are the doings of the second respondent and its officers. So, my lord, this application is intended to tie up all the loose ends in the referee's report. And we find it difficult to see what injury the respondents will suffer by the application. My lord, we have brought this application at the earliest opportunity. Immediately that the report was tendered in this court, we cross-examined.
That's why I do agree with you. The earliest opportunity was when the number was here.
And my lord, every point in this application was put to the witness. Every point I have made here was put to the witness.
If you now expected to make the request before agreeing to it,
It was an oral request, which the rules, and we're going by the oral request. Because, yes. Lord, like this application has been brought to provide the court. Very well.
Yes, that.
No, respectfully, my Lord, if I may reply, say a few things in response with your leave. Lord, is a new pursuit.
No, better resume your seat.
Wait.
After the lunch break, the proceedings continue. Yes.
Dr. Kojo Aparjan, you are reminded of your oath.
Yes, my Lord. Yeah. I will.
My Lord, I wanted to bring a matter to the notice of your lordships. When we ended yesterday, we expected that we were going to be given either pink sheets or a list of exhibits yesterday. My Lord, it is only this morning that I was given a list, 14 lists, my Lord. My Lord, yes, of lists of exhibits. 14 separate lists. The first one, out of 60, 30 were already included in the exhibit that was tendered by that is so, my Lord. So one wonders, the time involved in checking that alone, it was only given to us a short while before we started the sitting. So out of the 39, the 905, half of them were already included in the 905. My Lord, those that were not included, we will naturally have to check. We will have to check to be satisfied that they were indeed not signed. My Lord, if we had been given the exhibits yesterday, as expected, we would have had more time to do the checking. So we've eliminated in the first list of over 60, 30 that are already included in the ones admitted by Dr. Farijan and included in Exhibit P. We are now going to check the second list, my Lord, in view of the late delivery of the 14 lists. That is so, my Lord.
I think the order of the court was for you to deliver everything to them yesterday or something like that.
Yes.
And
My Lord,
this morning.
well, this had to do with the pink sheets in the custody of the court. And yesterday, Mr. Akotuampao was here. The registrar will bear testimony to that. He left here after 10:30. The understanding was that all parties will be present here to do this checking. Yes. And they were not here. So after this had been done, there was a problem.
Actually, you wouldn't expect them to be here to
Well, I also they ought to understand why they could not get it yesterday. And they were aware. We told them. We explained to them. They left here almost 11.
that you will not be ready even in the afternoon.
My Lord, I cannot take the risk because in this first list.
We will come and give our ruling anyway.
Very well, my Lord. Just to illustrate, in this first list of 59, there are already 32 which are included in the list, which was tendered through Dr. Farijan yesterday. So they need not have been included in this list. Now, the remainder are the ones that we will have to check to satisfy ourselves indeed.
We will not deny you the right to check.
Very well, my Lord.
We only want to know the exact time you think you would have checked your systems to clean it.
My Lord, there are 14 lists, so we will need till tomorrow. Tomorrow, my Lord. Well, I will give your Lordship 59, the first list, 69, the second list, 140, the third list, 12, the next one, 64, the next one, 40, the next one, 59, the next one, all given to us this morning, my Lord. And I'm finished.
Are those all the lists of the pictures you require them to verify? The list, the 14 lists you have given them.
Yes.
We believe they are you have exhausted your vote.
Those are the lists related to the no signature.
Oh, I see.
Well, I want to see whether it is feasible, because the non-signature, it will be apparent on the face of the record.
That is so.
You can't argue. So I want to suggest, I haven't discussed it with my brothers and sisters, whether even if it's possible, you bring all, and you all said that after a judge looks at them, it is okay. So that when you come to court, you say, okay, we looked at the 905, and then he admits that, okay, there was no presiding officer's A, and that is it. Because that one, it is not a question of interpretation. If there is no signature of the presiding officer, yes.
My expectation coincides with yours. I thought that is what they will do, but it looks as if they look at it without reference to Dr. Farijan. Yes. And it's only when in the box that he now has to go through all.
Yes, which is, I think, delaying the process a bit. So may I feel that for non-signature, it is there. It is apparent there. So that if you give them all of them, you sit with all the pink sheets you have sorted, then you look through them. When you come, you tell us that, oh, even on council on both sides, you have read, you look through, at least such and such, there were no signatures. Such and such, because there are signatures. Because he is now saying you have gone through, it's already on the list they gave you, and yet you are coming there again. Because they have considered. You see, my whole point is that where they have considered, I feel you should sort those out, the 905. And if there are others, which those that they are contesting, and then you are putting it to them, but even then, on the sheet, they say some are signed by agents. You leave it for addresses, because that's what the signature is there, it's apparent. Where the polling agents are signing some double, it is there. They have even made all their lists, so that you don't need to come in to be putting it to him.
Very well.
Actually, that is for their signatures. The others, some of them are contentious and the rest, yes. Like the overputting one, that one, if we are putting it to him, we knew you have to do it. Because he will say no, you say yes and all that. That's what signatures. I don't think you have to come to the witness box. So you have 10 people there, they have only one. Choose some of you and then let them sit down through all the thousands that you are claiming, and then perhaps that will be it. Those that there are signatures of polling agents will be one side. Those that there is nothing one side, and those that where the presiding officer too is not there. I think that can be agreeable because they have made their list, and even that list, the first page that we showed they should throw it away will even help you. He doesn't have to come here and say yes, there is no signature on it.
Well, no, we have no objection to that. That was our expectation, that it will be shown to the witness.
Yes. What is your problem, difficulty with that?
I would like to indicate that there are some that they claim to be unsigned according to the list that we maintain have been signed. And those, that is the one that we are going to check, my lord. We would need to check those, definitely.
Respectfully, we have actually tried to be of help in this process of weeding out what really does not need to be put to the witness. And when we looked quickly at this list of 140, which is the longest list, it is a list that is taken out of an earlier list of 266 that they made available the last time, which is now reduced. But in that list of 266, 224 were already in the 905 when we checked. 224 were already in the list. That is when it was the 266 list. Now, I'm pretty certain that of this 140, if 224 out of 266 were in the 900, clearly a lot of them should not be here. So, my lord, I think that respectfully, your suggestion is easier to actually comply with if they would take the first step of just making the list, more consistent with what is really needed by this court. And if that happens, I mean, we have been ready at a moment's notice to go through those lists, and we can still do that in the course of the break or the afternoon. But when we're given a list a few minutes before the court arrives, and we are going through it while trying to do other things, it's very difficult.
Because I feel we should not countenance anymore. Come in and then we have to wait for you to go through all this. Whereas you can sort it yourself. So, Mr. Addison, during the break time, think about what else we can do. Because this no signature or no, I feel it is not, for it to be there. It is there. They made a list. Both of you should clean the 904 or 5. And if you feel there are some, looking at the pink sheet itself, there is no signature, then that is the one that even I feel you should do it, not within time that we should be hearing the case. You have the personnel, a lot of lawyers, they have two each, one of them can all do it. So that we go and then you bring the really contentious matters, which as the EC, he has to, justify or whatever it is. But for no signature, we can all see it. And once they make the list, let some of your members look through it. And those that it is clear that after all they have considered, that's the point. So you don't have to bring the 905 here. That's the whole point I'm making. The 905 they have considered, don't bring them here. If there are others, but as I was saying, according to his list, some were signed by polling agents. So you check whether those he said polling agents have signed. You note it. And then where there is clearly nothing at all on it too, that one it is obvious. Where the party agents have signed. That one too is all obvious. So that you don't need to come and confront him with this. Because for that the evidence is clear. It's obvious that perhaps it's a matter of whether how you look at what entry is there and what the document is made.
Very well.
Please.
Very well.
Well, so we rise for the lunch break on the terms spelled out and adopted. But this lack of signature matter. All right. You bring this.